Hi everyone. As you now probably know, the legislation that will underpin the legalised discrimination permitting only vaccinated persons or persons who have recovered from COVID-19 to enter at a minimum indoor dining facilities was published late last night, July 13th, 2021, and the government intend this legislation to be voted upon tonight, July 14th, 2021. So the most important piece of legislation ever to go through both houses of the Oireachtas has been given just 24 hours for review by all TDs. The amount of time given for scrutiny of this legislation should illustrate the contempt that the government has for both TDs and the citizens of this country. But should we expect anything less considering that fascism has been normalised in the Dáil over the past 18 months? We will now take a brief look at the legislation as the time permitted does not allow anything other than this. The name of the bill is the Health Amendment No. 2 Bill 2021, and I've included a link in the description box of this video. The bill is split over 3 parts. Part 1 deals with the commencement date, expiration date and definitions. Part 2 deals with the provisions in relation to indoor dining restrictions, and Part 3 deals with amendments to quarantine upon entering the state, which I won't be dealing with as time does not permit. Part 1, Section 1.2 advises that the date of commencement of the Act shall be set by the Minister for Health at a later date. Part 1, Section 1.3 advises that the section dealing with indoor dining restrictions will continue in operation until the later of 1. the 9th of October 2021, or 2. if both houses of the Oireachtas agree, a later date not exceeding 3 months past the 9th of October 2021. That said, from experience we know that once this type of emergency legislation is passed, it is extended and extended and extended, so please do not take any solace in any purported expiry date. Part 1, Section 2 deals with definitions. In this case, the only definition noted is the meaning of the Act, which means the Health Act 1947. That said, there are a good number of further definitions set out later in the bill. Part 2 is the section we are most concerned about. Part 2 inserts new sections 31AB to 31AL into the 1947 Health Act. For the sake of being able to understand the next sections, we are going to jump to Section 4 of Part 2 to consider the most important definitions. So the first definition we will look at is permitted person. A permitted person means A person in possession of a proof of immunity. B, a person under the age of 18 or such other age under the age of 18 years as may be prescribed. So this means that they may change the age to 16, then 14, then 12 to encourage lower age groups to become vaccinated. So currently B is a person under the age of 18 who accesses a relevant indoor premises, 1, accompanied by his or her parent or guardian, or 2, on such terms as the Minister for Health may prescribe. Again, this section is too vague to comment on how it might be utilised. B, a person working at or in a relevant indoor premises. However, the Minister can later prescribe through regulations that this concession will not apply to certain classes of person. This too is concerning. D, any other person or class of person prescribed by the Minister for Health under Section 31AB4. So this could apply to persons who have previously been infected with SARS-CoV-2. The next definition we will look at is proof of immunity. Proof of immunity means A, the EU digital COVID certificate. You should remember that when this digital certificate was passed through the European Parliament in April of this year, we were assured by MEPs that it would never be used for domestic purposes, but here we are. B, a document confirming that the person has been vaccinated. Or C, any other form of written information or proof verifying that the person has recovered from COVID-19. Again, the only documents that will be accepted are those prescribed in regulations. The next definition we will look at is relevant indoor premises. So this is the type of premises that people can be discriminated in accessing without proof of vaccination or proof of having recovered from COVID-19. So a relevant indoor premises means an indoor premises A, on or at which food or non-alcoholic beverages may be lawfully sold or supplied for consumption on such premises. So this covers all cafes and restaurants that do not sell alcohol. B, any business or service that would otherwise be lawfully permitted to sell alcohol for consumption on the premises. So this covers all pubs and restaurants that sell alcohol. and C, such other indoor premises or class of indoor premises that the Minister for Health may prescribe through regulations. So, as we feared and expected, this is wide open for abuse, and abuse it the government will. The bill drafted today only restricts indoor dining in cafes, pubs and restaurants, but through this bill the Minister for Health can add any indoor premises to the list that he chooses. Back now to section 31AB. Section 1 of same provides that any regulations currently in force, so this currently applies to regulations 217, 267, 291, 304, 322, 329 and 341. That said, the main regulations you should review if you wish are 217 and 267. So any regulations currently in force which make it unlawful for a relevant indoor premises to open are disapplied where that premises follows certain conditions, including the following. A, that the indoor operator takes reasonable steps, including by inspecting documents to ensure that only permitted persons are admitted to a relevant indoor premises. B, that the indoor operator does not knowingly permit a person other than a permitted person to access a relevant indoor premises. C, that personal data such as proof of vaccination or recovery of the permitted person is not retained. D, that the indoor operator adheres to such guidelines set out by certain bodies as may be prescribed by the Minister for Health. So this means that there is a very good chance that they will add in more restrictions for these businesses, like the 1 hour 45-minute rule, or social distancing, or eating meals at tables and not bars, etc. E, that the indoor operator complies with such additional conditions that may be set for certain classes of businesses. Again, this is too broad to know what it might include. Section 31AB4 confirms that, in addition to the requirements just outlined, the Minister for Health can also make regulations. And don't we know how the Minister for Health loves to enact regulations when given the power to do so? So the Minister for Health can also make regulations in relation to the following. A, safeguards required to be put in place by persons in charge of relevant indoor premises, including by reference to persons or classes of persons being permitted different levels of access to such premises on the basis of different levels of immunity or resistance to, or vaccination or inoculation against COVID-19. This is concerning. Again, I don't know what the government intend from this section. The only thing that comes to my mind is encouraging booster shots to enhance immunity, thereby ensuring the person has full access to the indoor premises. E, defining other premises as a relevant indoor premises. This is important. So this means the Minister for Health can add other premises to the list of premises entitled to act in a discriminatory manner against those persons not vaccinated without having to go back to the houses of the Oireachtas for approval. Nothing could go wrong here. G, confirming that a breach relating to verification of proof of immunity is a Class C fine, which means a fine of up to €2,500. L, such additional, incidental, consequential or supplemental matters as the Minister for Health considers necessary or expedient for the purposes of giving full effect to the regulations under this section. Again, nothing could go wrong here. Section 31AC confirms that an indoor operator can request proof that the person is a permitted person. So this would include proof of vaccination, proof the person has recovered from COVID-19, proof the person is under the age of 18 years, or proof that the person is employed in the premises. If a person provides false proof, this again is a Class C fine. Section 31AE states that compliance officers may enter a relevant indoor premises without a warrant at any time and make an inspection. If the compliance officer believes that the law is not being adhered to, they can inform the indoor operator to take such steps as they consider appropriate, and if they do not, they may inform the guards. If the indoor operator still does not comply, the compliance officer can A, inform the guards, B, bring an application to the district court to apply for a 72-hour emergency cessation order of the premises, C, issue a compliance notice, D, where a compliance notice has been issued and it has not been complied with, an application for a cessation order can be made to the district court. The end result being that the district court can order the closure of that business in the case of a first offence for 7 days and in the case of a second or subsequent offence for a period not exceeding 30 days. These are the main provisions of the Act that people should be aware of, but please note that a thorough examination of the law has not been possible due to time constraints and wanting to get this information out this morning. Finally, you will likely be aware that many people are intending on gathering at the Convention Centre tonight to show their disdain that such legalised discrimination to enforce medical apartheid is being proposed by the Irish Government. If you can attend the Convention Centre tonight, please do. Thanks for listening.